Further hearing in the appeal WM Morrison Supermarkets against various claimants.
Good morning, my lady and my lords. Yesterday I finished by suggesting that while metaphysical uniforms and purporting to exercise an employer's authority might have their place in the appropriate factual scenarios, they can't be elevated to considerations of general principle in what is this wide-ranging area. Before that, I'd emphasise that it would be wrong when addressing Lord Toulson's second limb, sufficiency of connection, to treat Mr. Skelton's position or field of activities simply as defined by his tasking in relation to the particular audit exercise in 2013. What I want to do now is move on to the other aspects of the close connection approach which Lord Panic focused on orally, which were unbroken thread and motive. But before I do that, I just want to make sure that the court understands clearly the nature of the damages claims that are alleged by the claimants. That's in case it's thought helpful to try and marry up the tortious conduct in relation to the remedies sought over the unbroken sequence of events as found by the judge and supported by the Court of Appeal. So the place to go for that is the particulars of claim, which are in Appendix Part 2, and the reference in the middle of the page is 125, and the MS reference is 289. What I just want to show you is from paragraph 16 of the particulars of claim onwards, we plead, as we knew it at the time, what became the sequence of events. And so it begins on the 15th of November 2013 with one of Morrison's management information analysts providing the USB memory stick which contained the electronic file. 17 has Mr. Skelton copying it. That actually isn't strictly speaking correct because we think at trial it became the case that it was copied onto Mr. Skelton's computer, but that's a detail that doesn't matter. Then at 18 there is another episode in the story that doesn't matter, which is about the bounce back that was attempted when it was trying to be sent by email. And the story continues from paragraphs 19 down to 22, where we get at 19 the provision by Mr. Skelton of a copy of the file to KPMG. Paragraph 20, the complaint that Mr. Skelton didn't then delete it. At 21 is the allegation that at some time prior to the 12th of January, which was the date of first disclosure, Mr. Skelton created an electronic file, which is the file that's become known as the capital C copy. And then on the allegation on the 22 is that on the 12th of January 2014, Mr. Skelton uploaded it, which was the first of the disclosures. Now that's the pleaded case which we have had a trial about and we have findings about. The particulars then carry on, so that at paragraph 24, there is the reference to the newspapers receiving further copies from Mr. Skelton. 25 is then, if you like, the wrap-up averment. In the premises, that's everything that's gone before, the sequence I've just given you, the defendant was in breach of his obligations to maintain, and then the complaint is breach of misuse of private information, breach of confidence, and breach of Section 4.4 of the Data Protection Act. In paragraph 25, alleged against Morrison's the defendant. I then give particulars under paragraph 25, which we don't need to go to for the present exercise. But if you go forward to paragraph 26, which is bottom of the page 129, or MS number 293, you have the allegation of vicarious liability, which is the next paragraph, next main paragraph after the allegation of direct liability. Further, or alternatively, in all the premises, Mr. Skelton's actions were committed within the scope of his employment by the defendant, and the defendant is therefore vicariously liable for them.
So at that stage, you were pleading that that Morrison's were vicariously liable for his breach of the Data Protection Act?
Yes, in all the premises, and further, or alternatively, in all the premises. There is then...
But you weren't confining the claim to disclosure, were you, at that stage?
No, I wasn't, because I was complaining in all the premises, and the premises were, and included in the complaint at that stage was that Morrison's gave him the data, but Morrison's gave him the data, he copied the data for himself, he held the data, and then he disclosed it. So that was in all the premises. It wasn't confined, it never has been confined, to a complaint based solely on the disclosure of the 12th of March or the 13th of March.
So even if there had not been disclosure, you say that vicarious liability would have arisen, do you?
Yes, because the cause of action against Mr. Skelton arose on the 18th of November 2013, which was the time at which the judge described as his first unlawful act of copying, a finding which the Court of Appeal upheld.
What was the damage caused by that act
Well,
to your client?
in terms of distress, there couldn't have been any because they didn't know about it. What they did do, and what I'm coming on to make a submission about, is they lost the control. They'd already given control of the data to Morrison's by that stage. Morrison's control of the data was then lost at that point. And I'll come on and show you that the nature of the damage, I'll show you its damage as well as distress that we're seeking. The nature of the damage at that stage was the loss of control of the data. And as the Court of Appeal acknowledged, at that stage, if we'd known about it, we could have got an injunction.
Injunction to restrain what in particular?
Well, certainly to restrain Mr. Skelton from any further disclosure, for him to deliver up, if necessary for a third-party effect on anybody, any innocent party to whom he'd sent the information. And I dare say that the way these things tend to operate, there would have been, maybe successful, maybe not, maybe pointless, maybe not, there would have been proceedings against Morrison's at that stage as well. Because the scenario would have been...
Presumably you could also have sought an injunction to restrain him from making a copy, never mind disclosing it.
Yes. Well, except that until he made the copy, well, nobody knew. Chicken and egg.
It becomes slightly fanciful, but
yes.
If you became aware that he conceived an intention to make a copy.
If we knew before he made a copy he had an intention of making a copy, we could have sought quatermain relief. Once he made the copy, we had a cause of action. We could have sought relief under the cause of action to restrain him.
Yes. Could you have sought damages at that stage, as my Lord Hodge says? You hadn't really suffered any.
Well, I'm going to come on to explain why we can, and there the key would be loss of control between the 18th of November up to the point of disclosure. But if I can just revert to the pleading and complete the particulars. So we've got to paragraph 26. There is then at 27 pleading that you don't need to be concerned with. It's all about restraint and so on. But if you go over, please, to paragraph 28, which bottom of the page is 132, electronic 296. The plea there is that in consequence of the said disclosures, processing and breaches, the defendant of the 1998 Act and data protection principles, each claimant has suffered considerable distress, anxiety, upset, and damage.
What is the content of the and damage?
With the damage, what we say.
Well, this has now been to trial, so presumably
No.
So that aspect hasn't.
Now the parties agreed,
Yes.
Case management agreement, not to try the damages part.
That's right. Yes.
So that's not this is allegations and averments, not findings, and this will have to come later.
Yes.
Dependent on the outcome, obviously. But what we say, what we then did, because this is an area that's been subjected to some degree of scrutiny, is we were then pressed on our unparticularised pleas for damages. And what we did was we, in the end, offered voluntary particulars in the letter which Lord Panic showed you yesterday. And if you go to that, which is still in part 2 of the appendix, which is electronic 362, middle of the page 198. We gave the particulars in respect of each of the 10 lead claimants, and Lord Panic took you to the claimant at 2.1. You read it through yesterday. What I draw to your attention here is that in the case of each claimant, the circumstances, their experience of this loss and disclosure is set out. And so, for example, at 2.1, 4 lines from the bottom, one of the consequences is that the claimant now avoids online banking since she cannot, in the light of the disclosure, trust the processes that most people think are safe. And then, in common with all the other claimants, she says that she's lost control over her private and confidential information and personal data that were disclosed. What she doesn't say is that they were disclosed. She doesn't simply say they were disclosed and therefore I've lost control of them. What she says, and what her case is that she's lost control over her personal data. What personal data are those? Well, they're the ones that were disclosed. So what we have in the case of each lead claimant, and if you wish to read through, you'll see they've each got a different story to tell, but the common themes come through, that there are individual experiences of upset and distress in each case, and in each case there is a complaint at the heart of all of this, which is that they have lost control of their personal data. Now, on that second part, which we say fits within damage in the plea, as distinct from distress, which is a different form of damage, the case law hasn't reached the Supreme Court yet, but it's on the move. In the Gulati case, where Lord Panic appeared in the Court of Appeal, we know that in a privacy context, loss of control is a component of damage. And in the recent Lloyd and Google case, a similar view has been come to in relation to a claim under the Data Protection Act. So it's unformed.
I'm having difficulty understanding it in this context because it's perfectly obvious you don't have control over data that you've given to your employer, for example, for payroll purposes, or indeed data you've given to your bank if you're doing online banking. It's because you don't have control that Parliament and the EU have imposed obligations on the people who do have control of it.
Well, at the moment, I
mean, lots of people, for example, avoid online banking because, for that very reason, because they don't have control of the data, and they don't have sufficient confidence in the people who do. Now, the whole point of the Data Protection Act is to regulate the people who do have control, so that they take care of the data in a responsible way.
Well, it certainly introduces a regulatory obligation which is directed to reduce the risk of data processing. But at the moment, what I'm trying to do is, and these points have not been argued in this case because we haven't had our quantum trial yet. But the case, I'm showing you that the case is not simply that the claimants are complaining, that they're upset because their information was disclosed on the 12th of January. It goes back to the process. And so far as the component of their damage is concerned, which is to do with control, their complaint, but granted I've not won the argument yet, their complaint is that as at the 18th of November 2013, they lost control, or they had less control over it even than when they'd given it to Morrison's. That there is an awful lot of argument that can be had on this point. In the Gulati case, the phone hacking, there are all sorts of different scenarios where people didn't know their phones were being hacked, people didn't know their messages were being read, some people didn't know their messages were being listened to, some people could point to consequences, some people couldn't. But the component that's at play there is a loss of control. I'll come on and address the point that my Lord Reid makes about the Act providing regulation for data controllers so that these things don't happen. But it's actually to reduce the risk of these things happening. And in the present case, on my case, we're concerned with a situation with what has actually happened, notwithstanding the Data Protection Act and 7th Data Protection Principle. But I'm showing you this.
No, I just wonder, sorry to interrupt, but do you submit that when you relinquish control to either your bank by doing online banking or to your employer, that that's a conditional or qualified relinquishment, that you don't forsake all control of your data? You do so on the conditional basis that the employer will deal with that responsibly.
Well, yes, and in this case, according to the Data Protection Act, the processing can only be done in accordance with certain conditions. One of them is consent. Another is that the processing is done for a purpose or purposes which have been specified by the data controller. In the present case, I don't think it's been controversial. We say that we gave Morrison's our data for the purposes of them conducting the payroll. Morrison's conducted the payroll with it, but we didn't give them our data so that they could send us their latest offer about the Christmas turkey. That would have been impermissible on Morrison's part. We gave it to them so that they could process the payroll. So it is conditional, yes.
Well, you know, there is a statutory definition. The clue might be thought to be in the name, data controller, and it's defined as a person who determines the purposes for which and the manner in which any personal data are to be processed. So that is the person who actually determines these things.
Well, but the data controller must process the data in accordance with the data protection principles. If you go to the data protection principles, which are in...
Well, a data controller is still a data controller, even if he doesn't obey the Act. The Act imposes obligations upon him, but his failure to comply with the obligations doesn't deprive him of the character of a data controller.
No, I accept that. I thought my Lord was asking me a slightly different question, because my Lord Kerr was asking me about the situation where you give the data to the data controller. Do you give it away absolutely, or do you give it away conditionally? My answer is conditionally, because I'm giving it away for the purpose for which the data controller has told me he's going to process it. What I don't do is give it to the data controller on the basis that he can determine what to do with it. So if you go to the conditions for processing, sorry, I'm in the wrong bundle. It's at A1. Tab 1, electronic 398. So these are the principles by which, according to section 4.4, the data controller must process the data. Principle 1, personal data shall be processed fairly and lawfully, in particular shall not be processed unless at least one of the conditions in Schedule 2 is met, and in the case of sensitive personal data, at least one of the conditions in Schedule 3 is met. I'll go to Schedule 2 in a moment. But paragraph 2, personal data shall be obtained only for one or more specified and lawful purposes, and shall not be further processed in any manner incompatible with that purpose or those purposes. And then the other principles set out certain conditions about data being adequate, relevant, not excessive, kept up to date, not being kept longer than is necessary. But if you go to then Schedule 2, which contains the conditions, and that's at electronic 403, bottom of the page. We've actually only got the first part of Schedule 2, but it's all I need for these purposes. Paragraph 1 of Schedule 2 is that the data subject has given his consent to the processing. Now, if that is met, so the data subject has given his consent to the processing, then the first data protection principle will be satisfied in the case of personal as opposed to sensitive personal data. And the processing will then be fine, but provided it complies with the other data protection principles, including number 2, which is it is for the specified purpose for which it's been obtained. So what I say about that is that protects against the scenario where you give your personal data to a data controller, and because you've given your personal data to a data controller, they can legitimately decide, because they're a data controller, to do anything they like with it. It's not the definition of being a data controller that gives rise to their entitlement to do the processing. They're entitled to do the processing provided they satisfy the conditions, which typically in a case like this will be consent, and then that the processing will be for the specified purpose.
Before we leave the pleadings, could you help me on one point on which I'm unclear? The Court of Appeal, paragraph 37, raises a pleading point.
Yes.
And my understanding of 37 is that the Court of Appeal proceeded on the basis that the relevant causes of action, in respect of which vicarious liability was alleged, are in fact the two common law causes of action relating to breach of confidence and invasion of privacy, and not the statutory cause of action under the Data Protection Act.
Yes.
Am I right in understanding that?
I don't think you are, and I confess I don't understand the point myself, and I probably should have raised it.
I'm cheered by that.
When I received the draft judgment. Because if you go to earlier in the judgment, it's a while since I looked at this, but there are one or two passages in the earlier part of the Court of Appeal judgment where they seem to appreciate that we are suing or we were suing for primary liability under each of the three causes and vicarious liability in respect of each of the three causes. And that's the way the case has been argued. And so when it comes to the pleading point at paragraph 37, I'm afraid I think I have to part company with the Court of Appeal on that. But I also say I did nothing about it when I saw the draft judgment.
In your case, you presented on the basis of the three causes of action.
Yes.
For example, in paragraph 66.
Yes.
And it was that discrepancy which alerted me to it.
Yes.
Does anything turn on it?
Well, I don't think it does.
That's good.
I don't think it does, and I'm not conscious at the moment that Lord Panic is running that pleading point.
Can I make it clear? My understanding, informed by those alongside me and behind me, is that my friend is absolutely right. At trial, he argued for vicarious liability under the Act and at common law. And I take no point.
And that arises from what I asked earlier on the pleading.
Yes.
The paragraph is claiming it for all, in
Yeah.
respect of everything about which you're complaining.
Indeed.
The pleading point taken by the Court of Appeal seems to relate to the prayer.
I think that...
And they thought that as a result of that, the claim under the Data Protection Act was limited to the direct...
Yes, I think it probably is a reference to the prayer, yes.
Let's hope nothing turns on.
I'm grateful.
Thank you.
Could I just then, before we move back to Lord Panic's criticisms of close connection, I can just refer you, there's an interlocutory judgment in the core volume at 209, and this is going back to the case that we've been running. It's electronic 209. It's a case management conference. The judge had to give a judgment about various things which don't matter for today. But I would just draw your attention to paragraph 2 in the light of what I've been saying about what the nature of the claimant's case is. It doesn't come across perfectly, but I just want to make sure that the court appreciates that we have been consistent about this. About 5 lines down, the claimants each claim damages. This is not for any financial loss which they suffered by the disclosure of the payroll details, including their national insurance numbers, bank account details, named salaries, because there is, I've been told on an earlier occasion, no evidence that they've suffered individual financial losses directly attributable in any recognisable way to the disclosure of information. They claim for the assorted measures of distress they have suffered and for the lack of control of which they've been deprived by the behaviour of the disaffected employee in respect of the disclosure of documents. One can well understand why it is they might feel upset and worried about the consequences of that disclosure, some of which may yet have to emerge, and the risk of which emergence may be a factor for a later consideration. So that is a reflection of the case I presented to you today. The case management conference in question took place on the 12th of January 2017, so about 10 months before the trial. And it's always been this case that we've been putting, and we continue to put it forward. As I say, it's not been adjudicated. So I'd like to go back, if I may, to Lord Panic's criticisms and the second oral criticism that he made, which was of the unbroken thread finding. As we've already discussed today, the first unlawful act which the judge identified by Mr. Skelton was the act on the 18th of November 2013 during working hours at Morrison's headquarters, downloading the data from his personal work computer onto a USB stick, supported by the Court of Appeal. What we say is that that in itself was a tortious act, and we've discussed already how the remedies might have lay at that stage. Lord Panic yesterday suggested that by this stage, so this is the 18th of November 2013, Mr. Skelton was travelling to Inverness with no passengers on board, his reference to Williams and Hemp Hill. We disagree with that analysis. At this stage, nothing much had changed. Mr. Skelton was still working for Morrison's. Morrison still owed obligations to the claimants in respect of the payroll data, and Mr. Skelton was still charged by Morrison's to safeguard the payroll data. We don't think it's easy to transpose the deviation cases into the current facts, but if you do try, as Lord Panic tried yesterday, you still find that Mr. Skelton is responsible on behalf of his employer to take care of the claimant's interests. He is actually in an analogous position to the driver with the passengers still on board. He's going to Inverness or anywhere else, but he's still taking care of the passengers. That's the point. We then, as we go through the chain of events, move to the period at which Mr. Skelton was holding the information. He'd copied it, he then held it. That was independently tortious conduct in breach of the Data Protection Act. I won't receive an argument from Lord Panic if I say that holding is an act of processing for the purposes of the Data Protection Act. And of course he was holding private information and confidential information with no consent from the claimants to do so. So again, he's continuing to act tortiously. The nature of the tortious conduct changes. It goes from copying to holding, but it continues. And then we get to the 12th of January 2014, when he made his first disclosure, uploading to the file sharing website. We simply reject Morrison's argument that ought to be viewed in a vacuum as the only relevant tortious conduct. The uploading was a further tortious act which followed on directly from the holding, which had followed on directly from the copying. It was...
Could I just ask you something apropos holding? When he was given the data, the payroll data, was he entitled to read it and look at it?
Well, at that stage, he was acting on behalf of Morrison's, who were the data controller.
That. Was he entitled to read it and look at it?
Well, if that's what the data controller had tasked him to do, then yes.
Well, I'd like to know the answer to it, but it seems to me that he was entitled to look at it and read it because we were told by Lord Panic that he was to pass it to KPMG and keep it for long enough for him to be able to answer any queries that KPMG raised on it.
Well,
so he
yes.
was entitled to have it in his head?
Yes.
Okay, thank you.
He was tasked to have it in his head insofar as that required to deal with queries from KPMG. So my submission about disclosure is I simply part company with Lord Panic. If he tries to describe disclosure in a vacuum, and that because of the prior holding and before that the copying. If we then go to what the judge actually found, which is at 184, this is how he made the unbroken thread finding, and that's at core volume electronic 278. Now this is a long paragraph, And the reason it's a long paragraph is because there's quite a lot of detail in the middle of it, where the judge sets out his reasons. And we looked at this with Lord Panic yesterday, and the whole paragraph can, of course, be read at leisure. But what I wanted to do was just emphasise what the judge is doing here by reference to the way in which he starts out and the way in which he finishes up. What he does at the beginning is he's considering my learned friend's Ms. Proup's argument that the disclosure on the web of the payroll data was disconnected by time, place and nature from Mr. Skelton's employment. That all sounds very familiar because yesterday Lord Panic was talking about time, place and nature of activities. So this is the submission which the judge was considering. And he goes on to say, rather, he finds there was an unbroken thread that linked his work to the disclosure. What happened was a seamless and continuous sequence of events. He gives his, that's his headline finding. He then sets out, as I say, what his reasons for this are. And then about 6 lines from the bottom, he wraps up the paragraph, which begins with his analysis of Miss Proup's argument, where he says, these actions were, in my view, all part of a plan, as the research and careful attempts to hide his tracks indicate. As I've already noted, this is precisely the same view as that taken by Judge Thomas QC when sentencing Skelton. This was no sequence of random events, but an unbroken chain, beginning even before, but including, the first unlawful act of downloading data from his personal work computer to a personal USB stick. And the reason it was unbroken is because it isn't, as was argued yesterday, a series of but-for events that the judge is reciting. What the judge is finding here, having considered the matter, all the documents and all the witnesses at trial, is finding a connected and continuous course of tortious acting through from holding to from copying through holding to disclosure. What he is not doing, in my submission, is falling into an error of listing a series of but-for events and saying that because they all happened one after another, they made a sequence. He's finding a sequence of events. And in what the thread that runs through the sequence of events is Mr. Skelton's tortious conduct.
It might be stronger than that for you in the sense that it's a scheme. I mean, he's looking at Tor even before he receives the data. So there is an intention to, there might be devised an intention to commit a tortious act of a certain nature, or perhaps even a criminal scheme.
Yes. Well, the judge does say in the same paragraph that I've shown you that Mr. Skelton was acting according to a plan. And there's a separate criticism of that point that I'm going to come on to. But what I'm going to come on to say is that because the judge made an observation about Mr. Skelton working to a plan, which is my Lord Hodges' point as well, that comes through, the reference to Tor and so on, that doesn't invalidate the finding that there is a continuous course of tortious conduct. The continuous course of tortious conduct arises, it happened, and by the way, it looks like Mr. Skelton had a plan in all of this.
Could you just clear up one ridiculous little mystery? In the core volume and the memory stick version, the paragraph to which you're referring is paragraph 184
Yes.
of the judgment. But in the appendix,
Yes.
it's paragraph 183.
Well, I don't know about the precise mystery there, but I know my learned friends did a lot of work on this in the Court of Appeal, and what happened is that there are 2 paragraphs 35 in the original transcript of Mr. Justice Langstaff's judgment.
So somebody corrected it.
That then didn't follow through into the weekly report, And so what the parties have agreed to do is to put the weekly report in the core volume, but it will mean that the original appendix
No, that's a
is
simple
missing a
explanation,
paragraph.
and that's all I needed to know.
I'm very grateful to the other side for working that out, because it was completely beyond me. And I think it might actually have been Lord Justice Bean in the end who spotted 2 paragraphs 35, because he was working from the weeklies. This does actually bring me on to a point I mentioned a moment ago with my Lord Hodge, which is the criticism that the Court of Appeal used Mr. Skelton's plan to root his wrongdoing in his employment. Now, we've addressed that at our case, paragraphs 41 to 44. What we say is that the criticism of the Court of Appeal is that they considered the sequence of events to be established by the presence of a plan. What they actually did was they supported Mr. Justice Langstaff at paragraph 184 that we've just been reading. But what they didn't do is say anything more than the judge on that. And in particular, what they didn't do is get as far as a finding or a conclusion that it was the plan which made the sequence of events continuous. That the two concepts are separate, and I rely on the judge's finding for an unbroken sequence of events. I don't rely for the judge's finding on a submission that Mr. Skelton had a plan. That's just an observation that the judge made. And I say the Court of Appeal didn't make that mistake either. We've set out in our case why the criticism there is not merited. If I may just, in passing also, because we're on the unbroken thread finding, 2 other ways in which Morrison's addressed the point here is to refer to the Credit Lyonnais case and the Dubai aluminium case. As I've already submitted, we say that all the features of the wrong occurred in Mr. Skelton's employment from the 18th of November through to the 12th of January. I'm going to come on to other parts of close connection in a moment, but we're not running a case here, and we never have done, where we need to aggregate any conduct from anywhere else to bring it in, to associate it with what Mr. Skelton did in his employment. In the Credit Lyonnais case, the attempt was made to aggregate conduct from another wrongdoer into the employee's activities, so as to attach liability, vicarious liability to his employer. That's simply not what we're doing here. So we don't need any sort of Credit Lyonnais construction, and the Court of Appeal were right, we say, to dismiss Morrison's reliance on that, as they did at 65 and 66, supporting the judge's findings at judgment 189. What we've done, and again I think we say this in our case, is that we've satisfied the Dubai aluminium approach simply by showing that everything that, and obtaining a finding from the judge at trial, that everything that Mr. Skelton did was done by him, not by others assisting him, and within the course of his employment. Now, moving on to the argument over whether this is a mere opportunity case, Mr. Justice Langstaff at 185 recognised that it wasn't. He's well aware of the possibility of a mere opportunity case not being sufficient to give rise to vicarious liability, but at 185 is where he makes his finding about Morrison's deliberately entrusting Mr. Skelton, it was not merely something to which work gave him access. Dealing with data was a task specifically assigned to him. The Court of Appeal wasn't wrong to fail to recognise the case as a mere opportunity case, and it wasn't wrong because it saw the finding of Mr. Justice Langstaff and recognised that he had made a finding which dealt with the point. So, cutting to the chase, it's not a case where the office cleaner finds a thumb drive, picks it up, and takes the opportunity to make some use of it. We say, if one's talking about opportunities, one's talking about opportunities in the sense that Chief Justice McLaughlin talks about opportunities, which is Morrison's having given Mr. Skelton the opportunity to abuse the trust that's been placed in him, or abuse his position. But that's not a mere opportunity case. That's a reason for the imposition of vicarious liability. I'm not having an argument with Lord Panic to say that if this was only a mere opportunity, vicarious liability would not be established. And we've made clear in our case that we don't make that argument. We say it's not a mere opportunity case, and that's what the judge found. Now, in Jacobi, that we went to yesterday, we referred to paragraph 80 and steps 1 to 8 as a series of but-for opportunities. And the point was made that the majority in Jacobi complained that there was no nexus between steps 1 and 8, because step 1 was giving Griffiths the opportunity by the club to commit the assaults, and the assaults came at step 8. But everything else was just a series of opportunities which led to Griffiths being able to commit the assaults. Our reading of Jacobi, where the actual test that was being applied was whether there was a strong connection between his position and his abuse, is that the club, the point in Jacobi is that the club had not conferred power on Griffiths, who was the programme director, staff supervisor. What Griffiths wasn't, contrasted with the employees in Basley, is he wasn't employed to perform parenting functions in relation to the children. So he was the club's programme director, and as the club's programme director, the club did not give him the ability or the power to engage directly with children. In Basley, as I say, the foundation did. So we say that there are issues of time and place. There is an issue of nexus or causation in Jacobi. There will be in these multifaceted cases, but we say the driving factor in Jacobi is that it was never his job to be involved with the children. He was the programme director. And we say that's a clear contrast with the situation in Basley. Reverting to Mr. Skelton in our case, we say that Mr. Skelton had an analogous responsibility to the responsibility of the employees in Basley. Mr. Skelton's responsibility concerned the data. He wasn't, by virtue of, if you like, ex officio, he wasn't given privileged access to the data. He was actually given the data because he was tasked in relation to it as a part of his job. He couldn't have accessed the data at will, which is another way of looking at the super user point that I discussed with my Lady Hale yesterday afternoon. And so the data was in effect placed by Morrison's in his care. That's where the source of the problem comes. Of course, you can't say of the office cleaner that the thumb drive's been placed in their care, because in that situation, the thumb drive's just been left lying around and gives an opportunity for illegitimate behaviour. I'm going to move on to Lord Panic's third oral criticism, which was concerning the approach to motive. Motive is irrelevant. Lord Toulson said so at paragraph 48 of Mohammed. Lord Dyson also said so at paragraph 57 of Mohammed by expressly agreeing with paragraphs 47 and 48 of Lord Toulson. And of course, everybody else agreed with Lord Toulson without saying more. We say that Lord Toulson said that motive is irrelevant because
What he said was that Mr. Khan's motive was irrelevant.
Well, Mr. Khan's motive was irrelevant, and he said that because that's right. What we say is that the employee's motive actually says nothing at all about his field of activities, nor does the employee's motive say anything at all about the closeness of the connection between the field of activities and the wrongdoing. So to put it another way, if Mr. Khan's motive was irrelevant, so was Mr. Skelton's, and that's the point we make in our case. And we say here that the logic of the position has been demonstrated both by the judge and by the Court of Appeal. The judge at paragraph 190 made the point that the criminal motive in the fur coat case of Morrison Martin, or the deliberate dishonesty in Lloyd and Grace Smith, did not negative the findings of vicarious liability in those cases. The Court of Appeal reinforced that with the point that Mrs. Lloyd would have been left with no remedy against anyone but the employee if Morrison's argument is correct. And you can go on and consider the motives in other areas. In Mohammed, it was personal racism, and we have Lord Toulson's decision on that. In Mattis and Pollock, the Dorman case, the motive was violent personal retribution, and in Lister or the Christian Brothers, the motive was sexual gratification. A point I make is that where you're dealing with employees who are acting out of these motives, the reasonable person in the employee's position can reasonably foresee that what they're going to do is going to cause problems for their employer. It's going to result in their employer being sued. It may result in reputational harm. It may cause other difficulties. But just because that's the reasonable foresight of the employee doing the wrong, that could be said to be the employee's motive, or at least it's the employee's intention or an intention, because the law sticks the employee with that intention. But none of those considerations would negative a finding of liability, vicarious liability, for example, in one of the institutional sex abuse cases. I know my employer is going to get sued, but this is what I'm doing.
Yes, but the distinction I think that Lord Panic draws is that the purpose of the disclosure in this case was to harm the employer. The person who engages in sexual abuse doesn't have that as a purpose. Well, he may be sanguine about the possibility that the employer will be sued, but that's of a different character, is it not, from the present case?
Well, they're all of a different character. But the argument here, as I understand it, is about motive. The point I'm making is that it may be called purpose, or you may look at intention. But what both the judge and the Court of Appeal have done is identify motives in Morris, which was to steal the fur coat, which was undermining the employer's business. Lloyd and Grace Smith was a fraud, inevitably in some way going to damage the employer, and so on. There are logical reasons why what the employee is intending to do, or his purpose in what he does, or his motive for it, there are logical reasons why those don't speak to the scope of his activities, or a connection between the scope of his activities and the actual wrongdoing.
Well, it's at least an anomaly, is it not, that in a general sense, of course, we're not talking about the legal implications, that an employee who sets about trying to damage his employer should in fact provide the scenario where vicarious liability is incurred by his activity. And in the examples that you've just instanced, that was an incidental effect of the behavior rather than the express purpose of the individual.
But my argument is, whether it's incidental or whether it's central, it shouldn't make any difference to the analysis. If you wanted to look at this in a different way, a point I make is that Morrisons are not the only victims in this. We're told that Morrisons were the principal victims, and we're told that they tried to get a compensation order for £2 million and they got £170,000 and so on. But what is clearly recognised in the sentencing judge's remarks is that the act was a deliberate act to victimise the claimants as well. So it has, it's an action which has a variety of consequences. Morrisons, for the purposes of argument, wish to characterise themselves as the victims, but I say back, well, we're the victims too, but in terms of the legal approach to vicarious liability, I don't say that any of that's relevant. So far as the policy is concerned, what's relevant is that the loss that's occurred has arisen as a result of the risk of Morrison's enterprise. The particular risk that we're talking about is the risk, which can't be avoided, which is that you hire someone, you trust them, you ask them to do something that requires trust, and then, as in all human nature, they let you down. In that situation, where Mr. Skelton has let everybody down, the policy says that it should be the enterprise that bears the risk, rather than leaving the claimants to their own devices individually to see what they can do against Mr. Skelton. There was a case which Lord Panic relied on heavily from 1989, which is the Fire Brigade on Go Slow case. What we say about that, it's very unusual. It's an unusual outcome on specific facts. You saw from the report, I think, that it's an application of the Salmond approach to deliberate employee wrongdoing. And we say a clear example of why that approach has been shown to lack utility in that particular class of case. Indeed, I would go as far as to say that had it been brought to Lord Toulson's attention in Mohammed, it might have been one of those cases, along with the Keppel Bus Company case, that he listed to show why the Salmond approach is inapt. It's not a decision that I've been able to find has received any judicial notice since 1989. either supportive or otherwise. It wasn't considered, as far as I can see, in either Lister or Mohammed, and I've been careful to read the reports and the speeches. And we say it's an outcome that caused great injustice to the claimant, and we do say that if looked at through the prism of Mohammed today, the outcome would have been to uphold vicarious liability. It's certainly an outlier, but we say, on today's standards, wrongly decided. Could I just, before I leave this area, just refer you to, I mentioned a moment ago, Mr. Justice Langstaff's approach to victims and then the sentencing remarks. Mr. Justice Langstaff is at core volume electronic 280.
So the MS page?
MS is 280.
280, thank you.
I don't intend to reopen this, but just to show the court, Mr. Justice Langstaff's approach at 193. That said, Morrison's was not the only victim. The action here is brought not by Morrison's, but by Skelton's fellow employees. They claim not for the harm done to Morrison's, but that aimed at them. Trampling on their rights to the privacy or confidentiality of the data was a deliberate act by Skelton. A principal aim may have been to hurt Morrison's, but the method, and it may well be an aim as well, was harming their interests. The cases show too that the actions of housemasters in abusing children, and so on, it continues. But that's my point about Mr. Justice Langstaff recognising the victim status of the claimants to match that, I say, of Morrison's. If one goes then to the sentencing remarks, which are in Appendix Part 2, which is electronic 368, or page 204 at the bottom middle.
Sorry, what was your...
Electronic 368.
368.
The sentencing remarks actually begin at 367, but I was going to begin at 368, just a page or so in. At lines 4 and 5, you can see the sentencing judge recording his view. It was a cold and calculated and designed, no doubt, to do as much damage to Morrison's as could be achieved. And the judge then goes and recites various particulars of the offence. He then comes on at line 22 to other counts on that fraud is considered at line 17. 22, he then comes on to other counts on the indictment. Count 2 refers to your computer misuse, and count 3 refers to the disclosure of the data of the individual employees. The maximum sentence for these two offences at counts 2 and 3 is only 2 years, but looking at not just the damage to Morrison's here, but the damage to all those individuals, you knew without a shadow of a doubt that what you were doing here was not a financial attack on Morrison's, the company against you felt aggrieved. It was also an out-and-out financial and personal attack on all those individuals who are members of Morrison's staff, and indeed who you'd worked with. I say that because that self-evidently must be correct from what you did, but you yourself, when you posted this material to the press, said in the accompanying letter you sent that the files that were being disclosed to them contained enough personal data, I'm reading verbatim from what you said, enough personal data on each employee to steal their identities and or clear their bank accounts. And a significant element of that £2.5 million of loss, which is what Morrison's say they spent, is in fact financial consequences of what all those individuals have had to do to protect their individual identities. About £1 million or more, in fact, has had to be spent by those individuals, funded responsibly by Morrison's, to ensure that what you were talking about to the press has not in fact happened. So the sentencing judge saw part of the offence, part of the gravity of the offence, to be informed by the out-and-out attack made by Mr. Skelton on the present claimants, reflected also by Mr. Justice Langstaff's approach to the variety of victims which arise in relation to this particular tortious conduct. I wanted to move on to the fourth area of Lord Panic's oral submissions, which was policy. We've already said that we say the relevant policy in this area is really to do with enterprise risk, see Basley and Mohammed. In the case of, there are also references in the slightly older but Lister forwards authorities, which we say actually answer all of the defendants' assertion about a policy. So, for example, if one goes to Morrison, which is Core Authorities volume, tab 10 at electronic 594. If you could go to, electronic 599, which is paragraph 9 of Lord Nichols' speech. Whatever its historical origin, this common law principle of strict liability for another person's wrongs finds its rationale today in a combination of policy factors. They're summarised in Professor Fleming's Law of Torts. Stated shortly, these factors are that all forms of economic activity carry a risk of harm to others, and fairness requires that those responsible for such activities should be liable to persons suffering loss from wrongs committed in the conduct of the enterprise. This is fair because it means injured persons can look for recompense to a source better placed financially than individual wrongdoing employees. It means also that the financial loss arising from the wrongs can be spread more widely by liability insurance and higher prices. In addition, and importantly, imposing strict liability on employers encourages them to maintain standards of good practice by their employees. For these reasons, employers are to be held liable for wrongs committed by their employees in the course of their employment. So there, we say, is the answer to the criticism made of the Court of Appeal in the present case, where the Court of Appeal says liability insurance is available. It could easily have referred to paragraph 9 of Morrison, where Lord Nichols sets out that as part of the rationale. Liability insurance and higher prices. It's a price we all pay. There are similar points, or additional and similar points in Lister, which is at electronic 471, at tab 6 of the same volume. If one goes, for example, to page 65, paragraph 65, Lord Millett. Vicarious liability is a species of strict liability. It's not premised on any culpable act or omission on the part of the employer. An employer who is not personally at fault is made legally answerable for the fault of his employee. It is best understood as a loss distribution advice. See Keynes' edition of Attire, Accidents, Compensation and the Law, and the article cited by Attire in his monograph on vicarious liability in the law of torts. The theoretical underpinning of the doctrine is unclear. Glanville Williams wrote in Vicarious Liability in the Master's Indemnity that it's the creation of many judges who have had some different ideas of its justification or social policy, or no idea at all. Some judges may have extended the rule more widely or confined it more narrowly than its true rationale would allow, yet the rationale, if we can discover it, will remain valid for so far as it extends. And then there is more, which I probably don't need to read on. But I would also take you to a couple of passages in the Dubai aluminium case, and that is at the next tab 7. First of all, the passage which is at electronic 537, just beginning at the bottom of electronic 536. It's paragraph 107 in Lord Millett's speech. Vicarious liability is a loss distribution device based on grounds of social and economic policy. Its rationale limits the employer's liability to conduct occurring in the course of the employee's employment. The master ought to be liable for all those torts which can fairly be regarded as reasonably incidental risks to the type of business he carries on. See Attire, Lister and Hesley Hall. The American Law Institute Restatement of the Law Agency, Section 229, is to the same effect. The ultimate question is whether or not it is just that the loss resulting from the Servants' Acts should be considered as one of the normal risks to be borne by the business in which the servant is employed. Since this is the underlying rationale of the doctrine, there is no rational ground for restricting the liability to torts or for excluding liability in equity, particularly when equitable liability often has its counterpart at common law, and again, so on. The other paragraph I would take you to in the same judgment is 155. It's a shorter paragraph at electronic 548. Where here we're with Lord Millett still. The judge treated Amherst as independently liable to Duval as if they had personally committed a legal wrong, albeit innocently. But that is not the nature of vicarious liability. It is, as I've said, a loss allegation device. The employer is not a wrongdoer. He is not liable in respect of his own conduct. He is answerable for his employee's wrongdoing, and his liability is coextensive with that of his employee. He is personally innocent, but he is liable because his employee is guilty. So it's there already in the authorities, the policy argument, to answer Lord Panic. So far as the point about evidence for this is concerned, I'm not going to argue about fairness or otherwise, but it's true Morrison's produced no evidence to make good the various, as they have been called, doomsday, Armageddon and interim arguments they placed before the court. I would say one simply needs to go back to paragraph 9 of Morrison to see that those arguments have all been had before, and the answer is put your prices up and purchase some insurance. And so we get to a situation really where I've got a counter argument on behalf of data subjects everywhere for each of the policy arguments that Lord Panic put forward on behalf of data controllers everywhere. Yes, large amounts of data need processing. He's acting for a massive employer, which no doubt runs data management programs to promote efficiency and save costs in its business. It can afford and does to employ many thousands of people, but it runs an enterprise that comes with risk. There are limits on what a data controller can do to safeguard the data that it's controlling. It can't do it absolutely. I accept that. But by contrast, when a data subject gives over his or her personal data to a large organisation like this, they are giving it away. They know they're giving it away on condition that it's processed lawfully and on condition or in the hope that the employer will, that the organisation will comply with the regulatory obligations. But they are one more step removed from their personal data when they give it over to the enterprise than the enterprise is. If they give it over to the enterprise and it's part of the enterprise's risk in operating, then the policy says that it should be the enterprise and not the individual data subject that bears the loss when things go wrong. And then to follow up and to make a final point about policy in this area, I said at the beginning, this particular case that's placed before the court is a narrow one on its facts. And it's also a finding of liability that is regulated by the way in which the common law of vicarious liability operates. Vicarious liability on an employer is a strict concept, but it's only a strict concept once the conditions have been met. There needs to be the scope of activities satisfied, there needs to be the close connection between the scope of activities and the wrongdoing. If those conditions are met, then the policy favours a finding of liability against the employer. But if they're not met, and if they weren't met here, then of course we wouldn't be here. So we're dealing with this particular case. It's narrow facts, it's unusual, and it's also a case which has been regulated by the operation of the judge at first instance, having to make findings, having to make a judicial evaluation, and all of those things stand in the way of the employer's liability being made out. It's only if the claimant can prove its case on a proper basis that the liability holds. So we say that's where the balance lies, and one only has to look backwards at the by now very well-known authorities to see where the policy is when the employee has been acting in the course of the employment. Now, I'm going to move away, unless there are any questions, I'm going to move away from issue 1. I just mentioned the letter from the ICO. We've said something about that in paragraph 60.3 of our case. I think it can probably be implied from Lord Panic's own observations that we don't think the regulator's opinion on a partial basis here is really the sort of material that should be informing this court as to how the way in which the English law of vicarious liability operates. I don't think anybody's heard from the Information Commissioner since the Court of Appeal decision, but presumably Morrison sent it to them, I don't know. But that really is the end of issue 1 from my point of view, and unless there is anything else, I'll move on.
No, thank you very much, Mr. Barnes.
So this then is where Morrison argues for an employer's exemption under the common law of vicarious liability as it applies to the Data Protection Act, the law of misuse of private information and breach of confidence. This is what Lord Nichols in Morrison at paragraph 27 referred to as a special dispensation. The burden is clearly on Morrison's to show that the imposition of vicarious liability is inconsistent with the terms of the Directive and the Data Protection Act. We understand from the grounds of appeal and the written case, see for example paragraph 113, that Morrison's does not contend that the Data Protection Act was enacted as an exclusive scheme to govern any civil law aspect which might fit the definitions for the processing of personal data. There was a period during Lord Panic's submissions yesterday where he might have been going in that direction, but having looked at the transcript overnight at page 130, lines 9 to 18, he did, in closing that part of his submissions, seem to confirm that his bid is for an exemption from the applicability of common law vicarious liability to the various breaches, rather than anything that might be thought to be more ambitious. And that, Lord Panic's position in closing his submissions yesterday, would be consistent with the narrowed down way in which Morrison's has put this part of its case in the written case. For example, paragraph 93, where it said that the exclusion of vicarious liability in an entrustment case is evidenced from the following features of the data protection regime. And then the argument develops along the lines of if you have an entrustment case, that's where the DPA steps in to exclude vicarious liability, first for breaches of the DPA, and then for the, I'll call them the common law claims, misuse and breach of confidence. We do want to spend a moment first on terminology, just to make sure that everybody's on the same page when it comes to terms like data controller, and particular keeping your eye on the relevant set of data or the sets of data that are in play, because the terminology is very important in this technical area. Then I want to look at Morrison and the presumption that arises from it in relation to the operation of the statute. Then, of course, I'll have to say something about the scheme of the DPA and the directive and the policy. And then we'll have to move on and deal as best we can with the position in relation to the common law aspects. This is the part of the argument where you have to imagine the DPA has done what Lord Panic says it did to claims in relation to the DPA, and then get to a point where it does the same to vicarious liability in relation to misuse of information, breach of confidence. Before I move on to the terminology, though, I just want to try and set the context, because the whole of this part of the appeal, the argument for this part of the appeal, must proceed on the premise that we're talking about a situation where the employee has been found to be acting in the course of his employment. Because if the employee has not been found to be acting in the course of his employment, we won't have vicarious liability. We can't, for a different reason, which is that he's not in the course of his employment. So the whole premise is that we're dealing with a situation where the employee is in the course of his employment. So the situation that we have is that the data subject has entrusted her information to an employer. The employee then, without the employer's authority or approval, takes a copy, so becoming data controller of the copy. And then the personal information is disclosed or otherwise mishandled in contravention of the DPA, or for present purposes, I'll say the general law, and we can divide those up later. In that scenario, where the employee concerned has been acting in the course of his employment, Morrison's analysis is that the employer escapes liability altogether. There's no direct liability because the employer is not the data controller of the copy. That's Mr. Justice Langstaff's finding at paragraph 65 of the judgment. But there's no vicarious liability either, because on Morrison's argument, it's been excluded by the operation of the DPA. So we get to a situation where the data subjects got no remedy against the party to whom it gave his or her data. The remedy is against the employee. The employee is someone who the data subject is very unlikely ever to have had any sort of legal relationship with, whether it's data controller, data subject, confidant, or confider. It'll be somebody that the data subject doesn't know, an individual who works for the employer that the data subject doesn't know. Now, we say that can't be consistent with the aims of the directive, and therefore the aims of the DPA, for example, as recognised in Vidal Hall. I can take you to Vidal Hall in a moment, but for present purposes, the expression I have in mind is that the purpose of the directive, as per Vidal Hall, was considered to be the safeguarding of privacy rights in the context of data management. Nor, we say, does this analysis promote either of the directive's stated objectives. There's first the protection of individuals with regard to the processing of personal data, and secondly, the free movement of such data. And you can see those objectives if we go to the first volume of authorities at tab 2, electronic 404. Actually, sorry, the directive then starts at electronic 411. And you'll see Article 1, object of the directive. 1, in accordance with this directive, member states shall protect the fundamental rights and freedoms of natural persons, and in particular their right to privacy with respect to the processing of personal data. Number 2, member states shall neither restrict nor prohibit the free flow of personal data between member states for reasons connected with the protection afforded under paragraph 1. What we say is that the analysis put forward by Morrison's just doesn't match up to those objects. Nor, we say, is there any sort of special dispensation necessary to prevent the DPA in implementing the directive giving rise to disproportionate effects on data controllers. Because as we're going to go on and see, it's data controllers that are dealt with by the Data Protection Act. But in a way which, even on Morrison's own argument, gives rise to fault-based direct liability only. So there's no need for a dispensation for an employer, we say, where neither the directive or the DPA requires that. What Lord Panic noted yesterday, and he's handed the case in, is that he's not now arguing even that there is anything in support of the analysis he puts forward which could be said to be required by any harmonising effect required by the directive, in particular because the case he mentioned seems to indicate that that's not applicable where the directive is concerned with remedies under roundabout Articles 22 to 24. So that part of the application and grounds for permission to appeal has fallen away. So if I can move on to the terminology, and I don't want to weary the court, but I want to make sure that Lord Panic yesterday explained the terminology. I just want to make sure that we're completely at one with what it should be. Morrison's was always the data controller of the payroll data, capital P, capital D, and continued to be. One decision it took in relation to the payroll data is that it gave it to Mr. Skelton and trusted him with it. Mr. Skelton was the only data controller of the copy. And it was from the copy that he made his disclosures. Morrison's wasn't the data controller in respect of the copy, and it must follow, couldn't be said to be an employer data controller in respect of the copy. It is important, as well as distinguishing between the two data controllers at play, that one of them is solely concerned with the copy and the other one with the payroll data. One should not merge or align the notion of the payroll data or the copy, where Mr. Skelton is controlling one of them and Morrison's is controlling the other one. I'd say the terminology is important because by the time we get to paragraph 97 of Morrison's case, it is arguing for a position where it places itself as, I quote, an innocent, compliant employer data controller. And it seeks an exemption from the operation of the law of vicarious liability on that basis. First of all, we agree that in respect of the copy, which has given rise to the liability, Morrison's is not the data controller. So if we strip out the words data controller from Morrison's description of itself at paragraph 97 of the case, we're left with innocent, compliant employer. But the condition of being an innocent, compliant employer certainly does not ordinarily exempt an employer from a finding of vicarious liability. What exempts an employer ordinarily from a finding of vicarious liability is where the close connection test is not made out. But the premise of this argument is that the close connection test is made out. There was also some suggestion yesterday of Morrison's having been held vicariously responsible under the Act. It's not my case that Morrison's is vicariously responsible under the Data Protection Act. My case is that Morrison's is vicariously responsible under the common law in respect of breaches of the Data Protection Act, misuse and breach of confidence. So if I move on, if I may, to Morrison, which is where the rule comes from, and that's at sorry, where am I? Morrison. Tab 10, thank you very much. Tab 10 of the core authorities, which is, and I want to look at paragraph 17, which is at electronic 601. And this is the point about the presumption in terms of the application of the law of vicarious liability to statutory wrongs. Remember, the Court of Appeal agreed on that point. At paragraph 17, having discussed the matter in the previous paragraphs, Lord Nichols also agrees with the Court of Appeal. So the rule is that unless the statute expressly or impliedly indicates otherwise, the principle of vicarious liability is applicable where an employee commits a breach of a statutory obligation sounding in damages while acting in the course of his employment. That we characterise in our case as an adjunct to the general rule which was already in operation concerning other legal wrongs, common law and so on. But that's where the rule comes in. Lord Nichols has already established as a matter of principle there's no reason why it shouldn't apply to statutory wrongs. The question then arises, well, how's this going to work in practice? What should we presume? And the presumption is that unless the statute says otherwise, that enacted the wrong, then the principle of vicarious liability at common law will apply to the new statutory wrong. So we've set this point out in our case at 74, because when we read Morrison's case at 92, there seemed to be the suggestion that the question before the court is simply whether it was Parliament's intention that vicarious liability should apply to a breach of the DPA. We would characterise the question as rather more hard-edged in our favour. The question is whether, in the light of the presumption that vicarious liability does apply in respect of a breach of the DPA, Parliament has, by enacting the DPA, either expressly or impliedly excluded its operation in relation to a breach of the statute. I should say it can be seen from Mr. Justice Langstaff's judgment at 144 that he took this approach, bound by Morrison. The question is whether the DPA had expressly or impliedly excluded the operation, assuming that otherwise it did. So he took the correct approach. I don't understand that approach to have been challenged, but I do just make that clear in the light of the way in which Morrison's put its case at 92. Now, if we could then just go back to the Act itself, which I know Lord Panic took us to yesterday. It's at tab 1, Core Authorities Volume 1. And I'd like, if I may, briefly just go to paragraph 4.4, section 4.4, which is at MS page 392. And what the Act requires here, section 4.4, subject to 27.1, which doesn't matter for present purposes, it shall be the duty of a data controller to comply with the data protection principles in relation to all personal data with respect to which he is the data controller. I emphasise in respect to which he is the data controller because it is the data controller in respect of the processing of the personal data that he's data controller of, that the Act is regulating and addressing. We then, you've been shown DPP7, and we can go back to it if that's required. I don't think I need to. But the point we make about DPP7 is the obvious one, that it's not a defence to a claim under the Act to say that you've complied with DPP7. DPP7 is an obligation that's placed on data controllers by virtue of their being required to process data of which they are data controller in accordance with the principles, and it requires appropriate technical and organisational measures against unlawful or unauthorised processing. But if you do that, if you have in place your measures, and if you've taken steps in relation to the reliability of your employees, it doesn't give you a defence if there is some sort of disclosure which offends against the data protection principles, or if you're processing data which is inaccurate or out of date, or if you're keeping it longer than was necessary or it's excessive. You don't comply with those other principles, 1, 2, 3, 4 or 5, by being able to say, well, we've complied with DPP7. It's an obligation, but very much not a defence. And you can see that from the approach that Mr. Justice Langstaff took at paragraph 43 of his judgment. The approach is reflected by what he said there, which was essentially to deal with all but DPP7 first of all in his judgment, dispose of the claim on the direct claim there on the basis that for those data handling principles, Morrison's was not the data controller. But then he said, in relation to DPP7, I move on. They were the data controller in respect of the claim on DPP7. I will now decide the claim on that basis, the part of the claim which I lost. But I didn't lose that part of the claim because they were not the data controller, but I did lose the direct claim in relation to data handling on the basis of the finding that Morrison's were not the data controller of the copy of which Mr. Skelton was the data controller.
Are you going to come on to section 13?
I'm coming to section 13. So I was going to say that it is the only defence that the Act makes available, and it's made available in respect... We can look it up. Sorry, I've closed my bundle, but it's at tab 1, and it's electronic 393. No, it's not. Yes, it is. Yes, it begins at the bottom of 393. And you can see what it does is, first of all, it sets up in 13.1 an individual who suffers damage by reason of any contravention by a data controller of any of the requirements of this Act is entitled to compensation from the data controller for that damage. 13.2 over the page is the provision now that has to be read down in accordance with Vidal Hall about distress fitting in within damage. And then in paragraph 13.3, which is the defence, in proceedings brought against a person by virtue of this section, it's a defence to prove that he had taken such care as in all the circumstances was reasonably required to comply with the requirement concerned. Now, the person by virtue of this section, in section 13.3, I say can only be the data controller. And that's because of the way in which 13.1 introduces the data controller.
And also 13.2.
And 13.2 as well, yes, I'm grateful. So that's the way the defence works, and it's, in all the circumstances, was reasonably required to comply with the requirement concerned. So one then looks at what's gone wrong. It might have been a breach of DPP7, it might have been a disclosure without the consent of the data subject, and then one works out whether or not the data controller is able to prove that it took such care as in all the circumstances was reasonably required. The burden is on the data controller because it's a defence. I should say it's not a defence that's in play in this case, but that's obviously academic for the purposes of the current debate. Now, what we say about both the defence that we've just looked at and DPP7 that we looked at a moment ago is that they are addressed clearly to the data controller. They're not addressed to an employer. They don't provide an employer's defence. It's a data controller's defence and a data controller's obligation.
Well, it's providing a statutory cause of action, isn't it, to an individual in the position of a claimant in this case.
Yeah.
And it's a statutory cause of action specifically against the data controller.
Yes. The data controller in this case is Mr. Skelton. So we're with Morrison's, where, in particular in the passages I've identified in our case in the notice of appeal, that they describe the DPA as a fault-based direct liability regime, I would add for data controllers. But we part company with them if they then go on, as they do, go on to suggest that because it's a fault-based direct liability scheme for data controllers, it therefore excludes the possibility, given the right circumstances otherwise, of vicarious liability arising for an employer of someone who in the course of his employment, which is the premise for the current part of the appeal, breaches a data protection principle and therefore section 4.4 of the Act. It's like saying you can't have vicarious liability for negligence because the school in Lister resisted the direct claim for negligence that they'd been negligent in the selection of the warden. Yes, and they didn't appeal that. That's in paragraph 9 of Lord Stein's judgment in Lister. But it doesn't stop. In fact, the policy drives you towards recovering against the employer. And there is nothing in the DPA, nothing express, and obviously we say nothing implied, that disapplies that as a special dispensation, as Lord Nichols suggested is required, says is required, in paragraph 17 of Morrison. Yes, or 27. I'm going to move away from that unless there's anything more. I was going to just make a quick point about the GDPR, which Lord Panic raised yesterday, and it's this. I accept that in relation to the GDPR and the operation of the Data Protection Act 1998, my case is non-committal and ambivalent. I don't say whether the DPA 1998 is replicated in material respects by the GDPR and the 2018 Act or not. And I'm not going to. It doesn't seem to matter. But as I understand it, Morrison's do say, and indeed put forward as one of the bases for this appeal proceeding, that decisions taken about the 1998 Act will inform everyone going forward in relation to GDPR and the 2018 Act, which gives a mechanism to the regulation for the pursuit, for example, of domestic remedies. As I understand it, Morrison say, well, that'll be useful because if we have a decision on the 1998 Act, we'll then find out about how vicarious liability and GDPR and the 2018 Act work. Now, the point I make...
Sorry, that's not nice. I mean, I'm not inviting the court to pronounce under GDPR in the 2018 Act. It's not my case at all. simply said in passing that our understanding was that the issues will remain relevant. No more than that.
Well, we're here anyway, so the bottleneck of a point of general public importance doesn't require to be addressed.
Well, it's of general public importance because the issues of data protection are of general public importance,
right,
and will continue to be so.
But where does the GDPR take us?
The GDPR, the point I was going to make, perhaps I'm labouring it already, is that when the 2018 bill was being debated, which was to bring in the Act in 2018 in May to concur with the introduction of the GDPR, the Parliament, of course, knew the law and knew that Mr. Justice Langstaff had ruled in December 2017 that the 1998 Data Protection Act does not exclude the operation of vicarious liability for breaches of it. Now, we're being asked to look at what Parliament intended in 1998 when it brought the 1998 Act in. What I say about 2018 is that if Parliament thought that vicarious liability ought not to operate in the context of data protection, then it knew that Mr. Justice Langstaff, in his judicial position, was of a different opinion and made a different finding. And one would have expected to see Parliament in 2018 expressly legislate to disapply the operation of vicarious liability in relation to the GDPR and the remedies offered for the GDPR under the 2018 Act.
So praying in aid the Barras principle in the context of legislative inaction?
Yes.
Yes, well, I don't think we need to go into all the case law on that, of which there is quite a bit. It's a fairly controversial doctrine.
It's also pretty unlikely that we're going to say anything at all about the...
Well, I will move on to my next point. The next point is policy. And this is policy in the context. This is policy in the context.
I'm sorry, Mr. Barnes, could I just, for a moment, ask, how much longer do you think that you might be needing to...
I don't think I'll be very long.
I'm not trying to cut you short at all, or to dissuade you from taking your full allocation of time if you need it. But if you are going to do that, we might have a short adjournment. But if you're not, we'll wait till the end of your submissions and have a short adjournment then.
Well, I've regarded my ultimate guillotine as 1 o'clock, and I'll finish before then. If now would be a good time to take a short adjournment.
Oh, you've got to finish by 5 to 1.
I know. Well,
That's your time.
I will do with a short adjournment. I think Lord Panic may also be able to start before lunch.
Well, let us rise for a moment or two.
I'm just at the end of looking at the Data Protection Act and whether it gives the special dispensation for which Lord Panic contends. And I've said most of what I was going to say about policy already, so I'm not going to say it again. I do just wish, if I may, though, to place a check against the proposition that my clients are seeking disproportionate compensation or remedies. I mean, they're only entitled to behave proportionately within our legal system, and remedies are proportionate. Otherwise, they would be overturned. The individual awards that we contend for may well aggregate to a large sum of money by day-to-day standards. but it will end up being a sum of money, whatever it is, which simply represents a cost of Morrison's doing its business. What we can't do is look to bankrupt Morrison's by this. We're seeking compensation on an individual level for damages that certainly, compared to a commercial case, will be very, very modest. I say that without wishing to underplay the value of my client's claims to them. They will aggregate up. It will be a big number because I'm acting for 9,000 people. But none of that represents a policy as to why Morrison's, if they are legally liable, should not pay.
Can I just raise a matter and say at the outset that I appreciate that this is not a question that's been raised at any stage in these proceedings. You've not come prepared, either of you, to answer it, and I'm not expecting you to do so. I just have a little concern at the back of my mind. The more I've listened to the arguments about the DPA, the more it strikes me that there's something rather curious regarding the commission of a crime here as being regulated by a rather elaborate code of conduct under EU law implemented in the UK. And I see the scope of the directive, but we're told in the directive, Article 3, that it does not apply to the processing of personal data by a natural person in the course of a purely personal or household activity. And the Act in Section 36 is obviously designed to implement that provision and says that personal data processed by an individual only for the purposes of that individual's personal, family or household affairs are exempt from the data protection principles. Now, that would certainly cover lawful personal affairs. Why does it not, I just raise the question, why would it not cover unlawful personal conduct as well? I mean, there's obviously a distinction being drawn in the directive between personal activities and activities which are not of a personal nature, and the commission, well, the pursuit of a private vendetta by Mr. Skelton, in the course of which he commits these crimes. I just wonder whether that is a personal activity. I'm raising the point. I'm not necessarily expecting you to deal with it.
Well, for my part, I would need to think about that. And I suspect Lord Panic may wish to take advantage of it. But it's just never been raised. I wouldn't want to give you a response off the top of my head. The case that's in the bundle Lindquist is on, it's not on, it doesn't answer your Lordship's question, but it is a case which Morrison's rely on because of its domestic purposes nature. But that particular question, I really would want to, if I may, reserve.
Well, that's perfectly fair. And you know, if I had thought of it myself, I might have done a bit of research, and in the light of that, I might not have raised the question at all. But we're here now. This is the hearing, so I'm telling you what's in my mind.
Yes. Well, I can hear rustling to my right, so maybe there will be more enlightenment. So I think I've got to the end of the Data Protection Act excluding vicarious liability for a breach of the Act. We're not seeking disproportionate damages, and that's not a policy argument against us. We then move on to the next stage, where as well as assuming that the employee has been acting in the course of his employment, we also have to assume for the argument that the Data Protection Act has excluded the operation of the common law of vicarious liability in relation to a breach of the Act. So that's to assume Lord Panic's right on his first stage. We then need to go back to what the general rule is in relation to vicarious liability for non-statutory legal wrongs. And that is as per the explanation and Lord Nichols in Morrison, paragraphs 9, 10 and 16, the common law principle of vicarious liability makes employers liable for wrongs committed by their employees in the course of their employment. That's the general rule, and it was Morrison that added on to those wrongs breach of statutory duty. Now, we haven't found any authority which would see an act legislating to exclude the operation of the common law of vicarious liability in respect of a common law wrong, privacy, confidence, or any other common law wrong. Acts do, of course, abolish the common law or repeal previous acts and so on. But there we say the consideration moves into a case like Rotman, which is at Authorities 3, tab 34, at electronic 1096. This was a case that was certainly considered by the judge on the vicarious liability preliminary issues that he considered here. In Rotman, as I understand it, the question is whether the common law power of search and seizure following an arrest, did it or did it not survive the enactment of the Police and Criminal Evidence Act 1984 in an extradition case? So it's a fairly specialist question. What the court decided was yes, because there was nothing in the 1984 Act that evinced an intention by Parliament to revoke that power. Lord Hope dissented, but that was because he thought there was no applicable common law power in the first place. If one goes to paragraph 75 of Lord Hutton's speech, which is at electronic 1096, there is the principle which in this respect I rely on. And he said at 75, in my opinion, the common law power of search and seizure was not extinguished by Pace, and I consider with respect that the Divisional Court fell into error when Lord Justice Brooke stated at paragraph 47, I find it quite impossible to interpret part 2 of Pace as providing any saving for the common law power identified by Lloyd L.J. Justice Lloyd in Osman. But the question is not whether Pace saved the common law power, rather the question is whether Pace extinguished it, as Lord Justice Brooke had recognised in the preceding paragraph. It is a well-established principle that a rule of the common law is not extinguished by a statute unless the statute makes clear this clear by express provision or by clear implication. That, we say, is the principle that operates at stage 2 of Lord Panic's analysis here, and what he needs, therefore, is express provision or clear implication. Well, we know there's no express provision in the DPA for all the reasons I've given, but now addressing them to the question whether there's a clear implication that the DPA abolishes the common law of vicarious liability insofar as it applies to the laws of privacy and confidence. I simply say it's not there. It's not dictated by a scheme of the DPA. It's not necessary. Necessity isn't the test, but there isn't a clear implication either. So where we end up is we resist the argument that the DPA, even if it legislates in relation to itself and vicarious liability, we resist the notion that it can automatically therefore be taken to have legislated also in respect of privacy and confidence. There is, I think, on the arguments before the court, an agreement that one can match up on this analysis with reference to the CPAG case. One can match up the shape of the action under Section 4.4 of the Data Protection Act and the misuse of private information and the law of breach of confidence. One can match them up, but just because it's assumed that the DPA excludes the operation of vicarious liability in relation to a breach of the DPA, it doesn't follow that because the direct claims or the primary claims match up, that the DPA has gone that step further and taken out vicarious liability in relation to the common law, the primary common law claims as well. There isn't a principle that's been identified by way this to show how this operates as a matter of legal precedent. And what isn't even available now to Lord Panic is the argument that is a result that is required by the harmonising effect of the directive, because as he told you yesterday, he's not pursuing that argument. So what we do is we move on to look at the Court of Appeal's three main reasons for rejecting the appeal. The first one is it's said by the Court of Appeal that if a Parliament had intended, and here the Court of Appeal is actually, it's addressing the DPA, the common law and the breach of confidence points, albeit it does so by, it makes its analysis in relation to privacy and confidence, and then reaches back to say, well, the DPA, the answer in respect to the DPA will be dictated by this reasoning. But the first point the Court of Appeal made is that if Parliament had intended by the DPA such a substantial eradication of common law and equitable rights, then it would have said so expressly. Lord Panic says, well, that's a bad point because you can obtain these effects by implication. I would therefore step in defending the Court of Appeal and say, well, if there is a quibble with the language, albeit I say not the sense of their judgment, the point is that if the DPA had intended such a substantial eradication of common law and equitable rights, then you might have expected it to imply it or imply it more clearly. There's really nothing in the Act that we've been shown that implies this. We've been shown the Act as a direct liability fault-based regime, but that's it.
The quibble is the absence in the Court of Appeal's judgment of the words clear implication.
Yes. Yeah. Well, that's Lord Panic's, I would say, quibble.
That's using your word. Yes.
Yes.
That's your analysis of the point.
My analysis of Lord Panic's point is a quibble. Yeah. Yes, with respect. The second point that the Court of Appeal made, which we say is a good one, and I'm going to come on and expand on this slightly in a moment, but the point is that it's back to the objectives of the directive. The Court of Appeal's point is that if things work as Morrison say, then certainly doesn't secure or enhance the rights of data subjects, privacy rights of data subjects, but it in fact serves to curtail them because it leaves them without remedies in a situation in which what's gone wrong is something as the result of the action of an employee in the course of his employment with the employer to whom the data's been given. That curtails the data subject's rights, which is stepping in the opposite direction to the objectives of the directive and the Act. And the third point, on which I say the Court of Appeal was right, and I simply repeat my submission, is that the Data Protection Act actually says nothing at all about the liability of an employer. It's all about data controllers, and in the present case, the data controller is Mr. Skelton. Or in the example that we're considering, I should actually make that more general. In the example that we're considering, with the premise that's necessary for the analysis, the data controller is the employee who is acting in the course of his employment. That's what the Act is talking about. It is not talking about his employer, but I won't repeat myself.
Can I say, Mr. Lindquist, the reference you gave me to Lindquist is very helpful.
Oh.
There is actually guidance given on this very point.
Oh, well, I'm sorry, I didn't know that.
It's MS page 585, which is volume 1, tab 9. And the case concerned a woman who created a website containing information about her parish, and she relied on the exception for personal affairs. And you can see what the court says at paragraphs 46 and 47. So thank you for that.
Yes, well, it was
reassurance.
Reassurance, well, accidental, but I'm grateful. I don't think I have any more submissions, unless there's anything else from the court that will complete my case on behalf of the data subjects who seek remedies in this case.
Well, I think we've sorted out Lord Reed's question, but
Yes.
which is no doubt a relief to all and sundry. Yes, thank you very much indeed, Mr. Barnes, for your submissions. Ms. Joy? Lord Panic.
Thank you, my lady. Lady, my lords, Mr. Barnes began by making the valid point that there are two elements involved in assessing whether the employee has acted in the course of employment. The court needs to look at the field of the employee's activities, and it will want to look at whether the offending conduct was closely connected to those activities. Can I first seek to respond to my friend's points on the field of activities of Mr. Skelton? My friend pointed out that Mr. Skelton's job regularly involved the receipt of confidential information. We respond that Mr. Skelton did not have general access to the payroll data with which this case is concerned in its manifestation following the processing by Mr. Skelton. He did not have general access to it. He had access to it for a limited period of time and for a limited and specific purpose. That is for its transmission to KPMG for the audit in 2013. As in 2012, I accept he had the same task in 2012, and for answering any queries which KPMG may have had in conducting that audit. And all that's set out. It's uncontroversial. It's set out in the Statement of Facts and Issues at paragraph 8, MS page 63. Mr. Skelton did not otherwise have access to that data. He had no other function in relation to that data. His field of activities in relation to the relevant data was therefore narrow, and it was confined. And there was a very good reason, of course, why he did not have a more general access to that data. It was precisely because of data protection concerns. This is highly sensitive personal information. My friend sought to expand the area of the field of activities of Mr. Skelton by adopting the reasoning of Mr. Justice Nicholl in his obiter comments in the Axon case, the court will recall, and it concerned the trust and confidence which had been reposed in Mr. Skelton. That argument was advanced to Mr. Justice Langstaff, and it was rejected by his lordship. Can I show the court where Mr. Justice Langstaff addressed the matter? It's at MS page 281, and it's at paragraph 196. And
Sorry,
at one,
which
paragraph 196, near the end of Mr. Justice Langstaff's judgment. It's MS page 281.
Yes.
And at 196, his lordship began by saying that his conclusions on sufficient connection were fortified by the views expressed by Mr. Justice Nichol. But then he goes on, although, insofar as he based his decision upon a view of the source's job as including the task to preserve confidentiality, since she had an obligation to keep matters confidential, I have doubts as to its correctness. Where the issue is the identification of the field of activities of an employee, this is not necessarily to be answered by identifying the obligations that are an adjunct to those activities and are not activities in themselves, which do not in themselves constitute duties specifically entrusted to the employee in question. Mr. Barnes placed emphasis on the role of Skelton as being to preserve confidentiality for the same reason as gives me doubt about this part of Mr. Justice Nichol's judgment. I've placed no weight on it. And then he turns to what were the field of activities in his lordship's view of Mr. Skelton. We respectfully submit that must be right. The field of activities of an employee is not to be identified by ancillary obligations which apply to all employees, such as obligations of confidentiality. Indeed, we would also adopt the point that was put to my friend by my Lord Hodge. It's difficult to see how the field of activities can be expanded by reference to a negative duty not to do other things with the data. Can I move on to the criterion of close connection? I've made my submissions in opening, and I'm not going to repeat them, as to why we say that none of the actions of Mr. Skelton, neither the original copying nor the retaining of the data, and I accept my friend's point, there are three elements here. There's the copying, there's the retaining, and then there's the disclosing of the data. We say none of them were closely connected to his employment for all the reasons I gave in opening. My friend said there's no principle that the employee must be wearing a metaphorical uniform when the employee commits the wrong. And I respectfully agree. I'm not suggesting this is a panacea, a solution for all cases, but it is a helpful indicator of whether the wrong is closely connected to the employment, which is why Lord Torson used that concept. But in any event, I say what matters in this case is whether the disclosure was closely connected to the employment duties. And the reason for that is that this case is a case where the claimants are seeking damages for the consequences of the disclosure. And I showed the court in opening the letter of the 10th of November, the potted histories, which was at Appendix Part 2 and was at MS 362. And I invite the court to read that. It's very clear what these claimants are claiming for. But if there were any doubt about it, the matter is clarified by the interlocutory judgment of Mr. Justice Langstaff, to which my friend referred. Can I take the court back to that? It's MS 209. And the chronology here is that the letter that I referred to is a later letter. No, I'm sorry, it's an earlier letter. The letter is dated the 10th of November 2016. That's the potted history letter. And Mr. Justice Langstaff is giving his interlocutory judgment a month or so later, with knowledge of this document, on the 12th of January 2017. And at paragraph 2, at the end of paragraph 2, he sets out what he understands, what his lordship understands to be the nature of the claim. And it's the last 6 lines of paragraph 2 on MS 209. They, that's the claimants, claim for the assorted measures of distress they have suffered and for the lack of control of which they have been deprived. And then these words, by the behaviour of the disaffected employee in respect of the disclosure of documents. That's their claim. And if there are any doubt, he goes on to say, one can well understand why it is they might feel upset and worried about the consequences of that disclosure, some of which may yet have to emerge, and the risk of which emergencies may be a factor for later consideration. That is entirely consistent with the letter sent by the claimant's own solicitors at MS page 362, the potted history letter, which focuses exclusively on the consequences of disclosure, including loss of control. And I do not accept that it's open now to my friend to say what they're really concerned about is loss of control by reason of the original copying, not least because any damage that could possibly flow from the original copying would be nominal at best. And it would be nominal at best for reasons put to my friend by my Lord Reid, the Deputy President, that the claimants had in any event lost control of the data by handing it over to the employers, and in any event, Mr. Skelton was entitled to look at this data. It wasn't confidential to him. He was entitled to look at it in order to answer any queries from KPMG. And of course, this is precisely why the 1998 Act sets out a statutory scheme to address the consequent problems where data is handed over by data subjects. So we say this is and has to be a case about whether the disclosure was closely connected to the employment. But I repeat, we say none of the stages are closely connected to the employment. My friend made, I think, 4 main points in response to our arguments that Mr. Skelton's conduct was not closely connected to his employment duties. First, my friend said, and this was a continual theme of his submissions, that Morrison's took a risk in employing Mr. Skelton. They gave him the data. They must be responsible for what he did with the data. In my submission, that is an impossibly wide proposition which conflicts with principle and conflicts with the authorities. Vicarious liability is not an absolute liability. It involves assessment of all the circumstances of the case and an assessment of whether the wrong was closely connected to the job duties. Indeed, even in the child abuse cases, where something far more precious than data, that is a child, has been entrusted to the employee, vicarious liability does not turn on risk. It doesn't turn on the fact you have taken a risk and you've employed this man, it usually is a man, who's behaved in this way. It depends on a careful assessment of whether the wrongful acts were closely connected with what the employee was employed to do. And I showed the court in opening that Lord Stane for the Appellate Committee in Lister adopted the approach of assessing whether or not the offending conduct was closely connected to the job function and focusing on the specific job functions relating to the children, focusing on the grooming at work, and focusing on the fact that the abuse occurred in the place of employment. And that's the approach. Differences of view were expressed on different facts in the Canadian cases. But it's the same analysis. It's not, you have employed someone who has abused his responsibilities and you, the employer, therefore must be liable. And the proposition is inconsistent with so many of the authorities. The employers took a risk when they appointed the policeman in the BVI who used the gun for an improper purpose. The post office took a risk when they appointed the racist. The employers took a risk when they appointed the fireman who took industrial action. My friend has to say that all of those cases are wrongly decided. He has to say that Lord Torson adopted the wrong approach in Mohammed because Lord Torson did not say the employers took a risk when they employed Mr. Khan. My friend's second main point is that this case is analogous to Morrison Martin, the case that was where he ended his submissions yesterday evening. The case about the defendant's employee who stole a fur delivered to the defendants for cleaning. And the court will recall why my friend made that submission. He was understandably concerned to distinguish the present case from Lord Nichols' analysis in the Dubai aluminium case that is which radically conflicts with his approach. If I could take the court back, please, to Dubai aluminium. It's volume 1 of the authorities, and it's tab 7. At tab 7, and the court will recall that Lord Nichols is distinguishing two types of cases. At paragraph 27 on MS page 519, his lordship is leaving aside, as he puts it, cases where a firm or employer undertakes a responsibility to a third party and entrusts the discharge of that responsibility to the dishonest partner or agent. And then there's the Lloyd and Grace Smith apparent authority cases. And my friend is anxious to say that this case falls within the first of those because my friend's approach is fundamentally inconsistent with what Lord Nichols says at paragraphs 32 and 33, which recognises that where the employee carries out matters of a kind that he's authorised to do, but does it in a way that is a fundamentally inconsistent with what he's charged to do, then the employer may not be liable because it's a frolic of his own. See paragraph 32, see Lord Wilberforce's case of Kuragang Investments in paragraph 33. So that's my friend's argument. This doesn't fall within 32 and 33. Why? Well, because it's one of the categories that Lord Nichols has excluded. Now, I submitted in opening yesterday, and I maintain that this court has addressed Morrison Martin cases, and it has recognised those cases to be cases about a non-delegable duty of care. That is, they are cases where there is a primary duty owed by the employer which cannot be avoided by delegating the duty to a servant or agent. And I mentioned in opening the case of Arms and Nottinghamshire County Council. where my Lord the Deputy President gave judgment for the court, and Ms. Proops, I think, has just handed up. I'm sorry. The court, I hope, has in front of your Ladyship and your Lordship the case of Arms and Nottinghamshire County Council, where my Lord the Deputy President gave judgment for the court. Can I have one of these? Thank you. My friend's got a copy of it. And at paragraph 50 of Arms 2018 Appeal Cases 355, my Lord the Deputy President addressed this category of case, 50 and 51. And what your Lordship said at paragraph 50, disagreeing with Lord Justice Burnett's view in the Court of Appeal in the Christian Brothers case, talking about...
No. In the case of Arms.
Yes, in the case of Arms, paragraph 50.
No,
I mean, in Arms, I'm
I was
sorry,
disagreeing
it was
with Lord Justice
Your
Burnett
Lordship's
had
correct,
sat in the
of
court
course.
below.
Of course, Lord Justice Burnett's judgment was the
Case
subject of that appeal. And in paragraph 50, your Lordship is commenting on the view in the Court of Appeal of Lord Justice Burnett, and your Lordship says in the second sentence that with respect is to conflate two distinct legal doctrines with different incidents and different rationales, and to misunderstand the relationship between them. As explained earlier, it is the imposition of vicarious liability which is implicitly premised on the absence of direct liability. And then your Lordship says that a non-delegable duty cannot be breached by... Your Lordship doesn't agree with the proposition that a non-delegable duty cannot be breached by a deliberate wrong. See Morris and Martin, a bailment case which was treated as a case of non-delegable duty in Woodland's case. That's Lord Sumption's judgment for the court. And in my respectful submission, in order to avoid paragraphs 32 and 33 of Dubai Aluminium, and I understand why my friend wants to do that, he is, with great respect, doing what my Lord the Deputy President said must not be done, which is to conflate two distinct legal doctrines, that is vicarious liability and non-delegable primary duties. And my clients have been absolved of all allegations that they breached their primary duties in this case. Mr. Justice Langstaff found in our favour in all relevant respects in relation to that. And it's far too late, in my submission, for my friend to seek to defend a decision in his favour on vicarious liability by relying on a distinct doctrine of non-delegable primary liability. Indeed, Mr. Justice Langstaff was very clear indeed about that. If your Lordships go once again to Mr. Justice Langstaff at paragraphs 124 and 125 of his judgment, which is MS page 258. At 124, which is MS page 258, 124, the third and final sentence, his Lordship says, if Morrison's is liable, it must be vicariously or not at all. And for good measure, his Lordship repeats that at the end of paragraph 125 on the same page, MS page 258. If Morrison's is liable, it must be vicariously or not at all. The third point that my friend made in seeking to uphold the finding is that the disclosure can be traced back in a seamless and continuous sequence of events. It can be traced back to the origins. I maintain our position. At best, that links the wrong to the employment in a causal sense. It does not establish the necessary close connection between the employment duties and the tortious act for which damages are being claimed, that is the disclosure. And in any event, it could equally have been said in so many of the cases that there is a seamless sequence of events in the BVI firearms case of Hartwell, there was a seamless sequence of events. The rogue employee policeman had access to the firearm for work purposes. He took it and he went about his personal business of shooting into the bar. The seamless sequence argument was expressly rejected, I say rightly so, by the Canadian Supreme Court in Jacobi, paragraph 81. That was MS 2035. I won't go back to it because I cited it in opening. And the seamless sequence of events argument proves far too much. It would mean that we would be liable, I think I made this point yesterday, but let me make it again. We would be liable if we employ a butcher on the meat counter in the supermarket and we entrust the butcher with a very sharp knife. We give it to him, we give him access to her, we give them access to this knife to carry out the job. And the employee decides they're going to conceal the knife at the end of the working day. They're going to take it home. And we're going to take it home for the purpose of using it to stab the neighbour. And they carry out that plan. Or a data example that Mr. Skelton doesn't have a grievance against us. He has a grievance against his one of the work colleagues. So he uses this payroll data to identify the address of the person against whom he has the grievance, the person at work who he feels has slighted him or there's been some personal grievance. He goes to that address and he assaults the victim. We could not possibly be liable, in my submission. But there's a seamless sequence of events. And in any event, all the sequence proves is that Mr. Skelton had a criminal plan, the opening steps of which were carried out at work. And the criminal plan, far from linking the disclosure to his work duties, serves only to dissociate the disclosure from his job duties. My friend's fourth point was to dispute that motive can be relevant, even if it is to harm the employer. Now we say motive may be relevant, and many cases so established. Mr. Barnes has to say that all of these cases were wrongly decided. That is Hartwell, Irving, General Engineering, that's the Jamaican fireman case, the cases upon which Lord Nichols founded on the frolic of his own in Dubai Aluminium, paragraphs 32 and 33. Lister is wrong at paragraph 18, where the frolic of your own approach is approved by Lord Steyn. They're all wrong, my friend has to say. And in my submission, the court should avoid any such conclusion. But in any event, this is a remarkable case because, as in the Jamaican Fire Brigade case, the only other example that we found, the employee's purpose here was specifically to damage this employer. It is true, as my friend has emphasised, there were other victims, but they were not the targets. And it would be striking indeed if an employer is vicariously liable for acts specifically, wrongful acts, specifically aimed at that employer, when the judge has rejected all criticisms of Morrison's for hiring that person and trusting him. And the court may have noted that this point, can Morrison's really be vicariously liable for the acts of a rogue employee specifically directed at Morrison's, troubled Mr. Justice Langstaff. His lordship dealt with it right at the end of his lordship's judgment. It was MS page 282, if I could invite the court's attention to that. Paragraph 199 MS page 282, Mr. Justice Langstaff ends his judgment by saying the point which most troubled me in reaching these conclusions was the submission that the wrongful acts of Skelton were deliberately aimed at the party whom the claimants seek to hold responsible, such that to reach the conclusion I have may seem to render the court an accessory in furthering his criminal aims. Well, I wouldn't quite put it like that, but the court has the point. The court, by upholding vicarious liability, is enabling Mr. Skelton to promote his aims. I grant leave to Morrison's to appeal my conclusion, should it wish to do so, so that a higher court may consider it. We say Mr. Justice Langstaff was right to be troubled by that point. It is a particularly striking feature that makes it, in my submission, wholly inappropriate to say that the conduct of Mr. Skelton was closely connected with his employment. My friend then turned to policy, and my friend referred the court to the observations of Lord Nichols in Madrowski, paragraph 9, and I've already addressed insurance by referring to my Lord the Deputy President's observations in Cox, and Lord Nichols, if we go back to what Lord Nichols said in volume 1 behind tab 10, the passage that my friend read out at MS 599 made 2 points. It made a point about insurance, but then at the end of that paragraph 9, Lord Nichols says, in addition and importantly, imposing strict liability on employers encourages them to maintain standards of good practice by their employees. Well, we don't, with great respect, accept the relevance of that. It's a weak point in the present case where Mr. Justice Langstaff has rejected all criticisms of the employers for failing to prevent Mr. Skelton from acting as he did. The judge found that there was nothing else that we could reasonably or properly have done. And there's a further point. It's a point made by Justice Binney for the Canadian Supreme Court, Justice Binney for the Canadian Supreme Court in Jacobi, which is Authorities tab 5, volume 5, tab 64, and the relevant passage is at MS 2031, paragraph 73. This is Justice Binney for the court. As to the nature of the conduct, an employee who commits a sexual assault is committing a crime. Society has already placed a high deterrence factor on such conduct. The tortfeasor can face up to 10 years in jail for sexual assaults. There may be little an employer can do in reality to deter such conduct in its employees if the possibility of 10 years in jail is not sufficient. And I respectfully adopt that in relation to the conduct of Mr. Skelton. It's completely unrealistic to think, in the circumstances of this case, that vicarious liability would enable us to do more to prevent the events that unhappily occurred in this case. That's what I want to say on vicarious liability. May I turn to the Data Protection Act? My Lady the President put to me yesterday that it may not matter whether the court deals first with vicarious liability at common law or deals first with the Data Protection Act. I've thought about that question. I would suggest that the reason why it's more appropriate for the court to deal first with vicarious liability at common law is because the analysis of the case presented by my friend as to why there should be vicarious liability at common law assists the court in understanding why that argument falls fairly and squarely within the terms and the policy of the Data Protection Act. Because the argument that my friend is advancing is that my clients are liable for what Mr. Skelton did, precisely because we gave him access to the data. That's the case against us. We gave him access to the data, confidential data, which he then abused. And my argument is that the Act expressly addresses the liability of a person in the position of my clients as a data controller who hands over data, gives access to data to an employee, and what the consequences are. Now, as I submitted yesterday, there are two questions here. First, is there vicarious liability under the Act for the processing by a distinct data controller? Does my client owe a vicarious liability for the processing by a distinct data controller? And if the answer is no, does the Act exclude the common law vicarious liability which would otherwise apply on the assumption my friend is right? Now, it's important to be clear, because my friend was very clear, that in relation to the construction of the DPA, there's no dispute from my friend, and indeed Mr. Justice Langstaff found to this effect, that Morrison's is not, never has been, a data controller in relation to the copy. The only data controller of the copy is Mr. Skelton. And that's for the simple reason that the copy was produced by processing by Mr. Skelton entirely for his own purposes. Whether he was acting in the course of employment or not is irrelevant. He processed the data entirely for his own purposes, and therefore my friend accepts that the copy, which of course is the data that's then retained and then disclosed, we in Morrison's were never the data controller in relation to it. And what is striking about the Act is that the only obligations under the Act are on the data controller. Your Lordships and your Ladyships see this if we go back to the Act, which was Volume 1 of the Authorities, at Tab 1. We see this at MS page 392, Section 4.4, upon which my friend so heavily relies. Section 4.4 is very clear. It shall be the duty of a data controller to comply with the data protection principles in relation to all personal data with respect to which he is the data controller. Very simple indeed. The damages provisions, section 13, MS page 393, again, are only provisions imposing liability on a data controller. Individual who suffers damage by reason of any contravention by a data controller of any of the requirements of the Act is entitled to compensation. The same in section 13.2, and 13.3 for good measure makes it a fault-based obligation. And it's simply inconsistent with the terms of the Act and the evident purpose of the Act to make us liable at all under the Act for the conduct of a distinct data controller, here the employee. It is even more inconsistent with the Act when one recognises, as I submitted yesterday, that because the Act only imposes obligations on the data controller, Parliament has expressly imposed an obligation on a data controller not to dispose of data to an employee without taking reasonable steps to ensure their reliability. That's, of course, paragraph 10 of part 2 of Schedule 1 on MS page 401. My friend then says, well, that conflicts with the directive, with the purposes of the directive. And my friend took the court to the statement of the object of the directive in tab 2 at MS page 411. And Article 1 says that member states shall protect the fundamental rights and freedoms of natural persons, and in particular their right to privacy with respect to the processing of personal data. No dispute about that, but the directive specifically addresses on MS page 418 liability. And liability in Article 23 is a liability of the data controller. Member states shall provide that any person who suffered damage as a result of an unlawful processing operation or of any act incompatible with the national provisions adopted pursuant to the directive is entitled to receive compensation from the controller for the damage suffered. And there's then a provision that the controller may be exempted in whole or in part if he proves that he's not responsible for the event giving rise to the damage. So there's nothing inconsistent with the directive in the approach for which we contend. So we maintain our position that to impose vicarious liability in respect of a breach of the Data Protection Act would be fundamentally inconsistent with its terms and its purpose. The question then, and the final question, and an important question, is whether the DPA excludes what would otherwise be the common law vicarious liability of the employer for what the employee has done in the course of his employment. And what is crucial in my submission when the court considers that question is to bear in mind that in this case, the vicarious liability is said to result from the act of the employer in giving the employee access to data. That's what this case is about, and is only about. That's how my friend puts his common law case. He says, we, the employers, are vicariously liable at common law because we have given access to this data to an employee who has then abused the powers that he then had. And I say that where we have an Act of Parliament that specifically addresses the legal consequences of such action, it cannot be the case that even though the Act denies vicarious liability, the common law retains it. The whole point of this Act is to address and regulate the very difficult and sensitive balance between competing interests. And the interests are the interests of the data subject, the interests of the public in the free flow of data, and of course the interests of data controllers that they should not be held liable where they're not at fault. And it's a difficult balance, but that's the balance that Parliament has struck. And in my submission, the Rotman case, Lord Hutton's statement on which my friend relied, cannot assist. And it cannot assist because the test has been set out more recently by Lord Dyson for the court in the CPAG case at volume 1, tab 11. And the test is not whether it is a necessary implication of the statute that the common law no longer applies. The test, I remind the court, I don't ask the court to turn it up, but it's volume 1, tab 11, MS page 636, paragraph 33. The question is whether the two remedies cover precisely the same ground and are inconsistent with each other. That's the test. Rotman, incidentally, was cited in argument in the CPAG case, but is not referred to by Lord Dyson. And I repeat the point I made in opening, that for Mr. Justice Langstaff, see paragraph 195 of his Lordship's judgment, MS 281, the outcome, I quote, would be the same irrespective of whether a breach of duty under the DPA a misuse of private information or a breach of the duty of confidence was concerned, for the essential actions constituting a legal wrong in each case were the same. That's our case. Paragraph 195 of Mr. Justice Langstaff. So we do maintain the proposition that if I'm right, that the DPA does not permit of vicarious liability, it cannot remain the law that the employee can be better off by claiming under the common law when the alleged vicarious liability is based on the act of the employer in giving access to the employee to the data, a matter specifically regulated in a statutory scheme, paragraph 10 of the schedule, a matter specifically regulated in a statutory scheme which is designed to allocate responsibility proportionately and fairly and properly as between different data controllers. That's our case in relation to that matter. My friend said that if in 2018 Parliament had intended to overrule the judgment of Mr. Justice Langstaff, it could and would have said so. Parliamentary sovereignty is, of course, a wonderful thing, but I invite the court to take judicial notice that what Mr. Barnes suggests is not how Parliament works. I mean, it really doesn't proceed on the basis that Parliament, when it passes legislation, is going to look carefully and pass judgment on the views of Mr. Justice Langstaff in an earlier case. Finally, I mentioned yesterday, in the light of the recent judgment by the Court of Justice in Fashion ID, we are no longer contending that our submissions on the Data Protection Act gain further support by us relying on the directive. I've relied on the directive in answer to a point made by my friend. And my lady, the President, asked me to identify which paragraphs of our written case can be deleted, and they're the ones addressing harmonisation as an object of the directive. And it's paragraphs 81, 82, 98, 115, the final sentence of 120.3, and the second sentence of paragraph 121. We can send that in writing if that would help, but those are the paragraphs. That's not the most positive way to end my submissions in reply.
Oh, don't be just
The court will say in due course
concessions are always welcome.
Indeed. The court will say in due course whether my other submissions are more persuasive than the ones I've abandoned. That's what I wanted to say. Thank you very much indeed.
Thank you, Lord Panic, and thank you to everyone. Not only those who've been on their feet, but those who've done all the hard work behind the scenes, as I know they have. We will now go away. This is one of the most interesting cases. All our cases are, of course, fascinating, but this has a particular fascination, and we will go away and try and work out what the answers are. Thank you.